Welcome to SEO's daily Supreme Court update. At 2 o'clock yesterday, Courtroom 7 was bustling with a swarm of lawyers waiting for the Hijab Ban case to begin. Justices Hemant Gupta and Sudhanshu Dhulia were hearing the second day of arguments in the challenge to Karnataka's Hijab Ban in educational institutions. Senior advocate Mr. Devdutt Kamath tried to convince the court that it was crucial that the case be referred to a constitution bench. He stressed that this case was not just about whether the Karnataka government could make laws on uniforms and dress codes. It involved constitutional questions about making reasonable accommodations for religious practices. Reasonable accommodation means an adjustment or facilitation made to allow a person to fully and effectively exercise their rights. Mr. Kamath argued that the Supreme Court has recognized a right to education under Articles 19 and 21 of the Constitution. The state has the responsibility to ensure that they accommodate citizens' diverse needs and beliefs so they can exercise this right. He argued that the students in Karnataka were only asking to add a headscarf to the uniform, not to cover the uniform with the hijab entirely. This was a reasonable accommodation that the state must allow. Mr. Kamath took the court around the world in almost 80 minutes to explain what the reasonable accommodation means. He cited judgments from the constitutional courts of South Africa, USA, UK, and Canada to explain that reasonable accommodation is crucial to secure dignity of all citizens. The bench was impatient through this world tour. Justice Gupta emphasized that India's diverse cultural and religious contexts cannot be compared to these other countries. Mr. Kamath was careful not to make an essential religious practices argument. He stated that the government can restrict one's right to practice religion only on the basis of public order, morality, health, or if it infringed another person's fundamental rights. In this case, he argued that the government failed to show how the wearing of the hijab affected any of these factors. Mr. Kamath attempted to argue that the Constitution guarantees a right to dress as one wishes as well, under Article 19. The bench objected, with Justice Gupta mockingly saying that this was taking the provision too far. What would the petitioner argue next? The right to undress? Mr. Kamath will continue his arguments tomorrow. In another interesting update, a 5-judge constitution bench led by Justice D.Y. Chandrachud called itself a green bench and decided to go paperless. Lawyers were directed to file all paper books and documents digitally. This bench will hear 2 politically charged cases in October: the tussle between Union and Delhi governments for the control over the capital's civil servants and the Maharashtra political crisis.